People in crisis are turning to artificial intelligence for help. They use companion chatbots as makeshift mental health support, often in their most vulnerable moments. Without human oversight, these unmonitored digital relationships have led to real-world tragedies. States have tried to intervene. California passed its mental health AI architecture with a unanimous vote. Louisiana and Vermont pushed similar privacy and disclosure bills through their chambers to protect their residents. But the developers building these tools rely on a specific strategy to avoid local laws. They lobby to block oversight, argue that the text generated by their models is protected free speech, and keep their safety testing hidden inside proprietary black boxes. A unanimous vote in California only matters if the state has the right to enforce it. The map of state-level AI regulations is fragile. Without an active defense, those local laws can be wiped off the books before they ever take effect. To hold developers accountable when the federal government fails to act, states require three distinct components working together. They need the legal authority to write the rule, they need a courtroom precedent to enforce it, and they need an open clinical standard to measure exactly what safe looks like. Jeff Jackson traded a vote in Washington for the power to enforce the law at home. He resigned from the U.S. House to become the Attorney General of North Carolina. In the fall of 2025, lawmakers in Washington moved to erase state AI laws outright. They tucked a provision into the National Defense Authorization Act, the must-pass annual military funding bill, that would have banned states from passing or enforcing their own regulations on the technology. Jackson fought back. He organized a bipartisan coalition of 36 state attorneys general and sent a joint letter to congressional leaders demanding they strike the provision. That pressure forced Congress to drop the preemption clause. He paired that defense with an affirmative push. Days earlier, Jackson and Utah Attorney General Derek Brown launched a nationwide AI task force to bring developers like OpenAI and Microsoft to the table directly at the state level. Defending that jurisdiction secures the foundation of the entire regulatory map. If the federal government strips away the authority to act, every local AI bill is void. A statute on paper does not change corporate behavior until a judge attaches a financial cost to breaking it. That happens in civil court. When families sued over chatbot-related deaths, tech companies reached for the First Amendment. They argued that the text generated by their models was protected speech, putting their outputs beyond the reach of standard product liability laws. Attorney Mitali Jain successfully dismantled that defense. Representing the family of a teen who died after interacting with a chatbot, Jain pushed back. In May 2025, a federal judge in Florida agreed with her, stating the developers failed to explain why words strung together by an algorithm qualify as speech. Look at how this shifts the legal framework. The court declined to treat the chatbot as a speaker with constitutional rights. Instead, it treated the chatbot as a manufactured product. A defective product that causes harm can be sued. Jain is now using that exact product liability theory at scale. Her organization has 12 pending cases filed against OpenAI in California, arguing the company released tools designed to manipulate users. By proving the First Amendment does not shield these models, Jain built the legal doorway that every future plaintiff can walk through. Regulators and lawyers face a final practical hurdle. You cannot enforce a safety rule if no one agrees on how to measure what is safe. Harvard clinical scientist Dr. Kate Bentley solved this. In October of 2025, she published Vera-MH, an evaluation system designed specifically to measure the safety of artificial intelligence in mental health scenarios. Her standard runs simulated conversations to test one critical requirement. When the automated system detects a user in crisis, does it recognize the danger and hand that person over to a human clinician? This chart shows the benchmark's reliability compared to human experts. Individual clinical experts agree with each other on these risk assessments at a rate of 0.77. The automated judge used in Bentley's standard aligned with the expert consensus at 0.81. The machine tracked the required standard tighter than individual experts did. Bentley could have licensed this evaluation metric as a proprietary asset. Instead, she released it entirely open source, giving the data and methodology away for anyone to use for free. A company claiming its tool is safe finally has a concrete way to prove it, and the legal system has a validated yardstick to hold them to. A single clause in an appropriations bill could have erased the state's right to act. A free speech motion could have blocked the lawsuits. Proprietary testing could have kept the algorithms hidden from public scrutiny. An attorney general, a litigator, and a clinical scientist approached the problem from completely different angles. Working independently, they neutralized each of those industry shields. State legislators now have the jurisdiction to write laws. Plaintiffs have the precedent to sue developers for defective code. Regulators have an open standard to define what safety requires. The legal framework that protects the public from artificial intelligence does not build itself. It holds together because people fight to keep it standing.